Hi, I'm Ben Sheffner, and I'm here with my colleague John Paul Jassy, and we are here to talk to you today about anti-SLAPP developments in California and beyond. Just to do some quick introductions before we get to the substance. Again, my name is Ben Sheffner. I'm Senior Vice President at the Motion Picture Association of America in Los Angeles. I handle mostly copyright policy issues, also a variety of other legal issues affecting the members of the Motion Picture Association, including various litigation-related issues, including the one relevant to us today, anti-SLAPP statutes.
I'm Jean Paul Jassy. I'm a partner at the Los Angeles office of Jassy, Vick, Carolyn, and I do litigation, a lot of First Amendment media litigation, and I've done dozens of anti-SLAPP motions in state, federal court, court of appeal, trial court, so it's great to be here with Ben today.
Before we get into the substance, let me talk to you a little bit about the basics. SLAPP is an acronym. It stands for Strategic Lawsuits Against Public Participation. And what does that mean? Back in the 1980s, a number of academics and others noticed a problem. That was lawsuits were being filed essentially to shut people up who participated in the political process. It was generally large corporations suing a little guy, not because they necessarily had a meritorious lawsuit, but they just wanted the little guy to go away. So what various state legislatures started doing back in the late 1980s is enacting what were known as anti-SLAPP statutes. And those are basically state laws that provide a mechanism for a relatively quick, cheap resolution of lawsuits that target exercise of First Amendment rights on a public issue. And let me just give you a flavor of the type of lawsuit that these lawsuits target. The typical scenario is this. A developer announces that they're going to put a development project in a particular neighborhood. And some of the people who live there don't like it. So the residents organize. They might put up billboards, they might speak out at their local city council or planning and zoning meeting, and of course the developer doesn't like this. They want to win the ability to put their development where they want it, and so they hope these people go away. So they might sue them for defamation, for interference with their prospective business advantage, etc. And again, these people, they may not be wealthy, they might not have all the money to hire lawyers and fight years-long battle in the courts. So the hope is, on the developer's part, that these people just go away. Again, legislatures starting with Washington State in 1989 saw this as a problem and enacted laws to address them.
Right, and one of the reasons why these developers will file these lawsuits is just to tie up the defendants. And so the defendants will basically give up and say, well, it's just easier, it's cheaper for me to stop complaining, stop talking. And that was really what the concern was.
Right. So JP is going to focus in on California, where we've had a very strong anti-SLAPP statute on the books since 1992. Describe a little bit about how the statute works in practice.
Right. So California does have one of the best or the strongest anti-SLAPP statutes in the country. And the procedure is a two-step process for using or invoking the anti-SLAPP motion in California state court. So what happens is this. If a defendant gets served with a complaint or with a cross-complaint, they have 60 days to bring an anti-SLAPP motion. And the anti-SLAPP motion in California State Court is called a special motion to strike. So it's a special procedure to try to target causes of action or even parts of causes of action within the complaint that arise from protected activity, meaning activity that is generally protected by the First Amendment, speech or petitioning conduct. So what does the moving defendant need to show in step one of the analysis? So the burden is on the defendant in the first step of the analysis. And what the defendant needs to show is that the targeted cause of action, and it doesn't have to be the whole complaint, right? It can just be a part of the complaint, just one cause of action or even a part of the cause of action, arises from speech or petitioning activity. And there's 4 different ways that this can be shown, but they can really be grouped into just 2 main categories. The first category is statements made in or in connection with an official proceeding. So let me give you an example. If, for example, the plaintiff is suing the defendant for something the defendant said, let's say, in a lawsuit, or maybe said, as Ben was talking about, at a public hearing talking about a real estate development that would be coming up, or that was said in a police report that was filed with the police. Those are all types of official proceedings. So if the defendant is being sued for what they said in the context of that official proceeding, or if what they actually said in the proceeding itself, let's say in a court filing or on the witness stand or something like that, then the defendant can show that the anti-SLAPP statute applies, okay, in step one. That's one category of ways, all right? The second category is statements or conduct that's concerning a matter of public interest. There, the defendant has to show basically two things. The first is that the cause of action is targeting their speech or petitioning activity, and then they also have to show that that activity is a matter of public interest. And we'll talk a little bit about what the matter of public interest means in context.
So JP, you mentioned that you can target specific causes of action. Now, typically, people know a little bit about the anti-SLAPP statute. They might think, oh, this is about defamation cases. Does the statute actually limit it to particular types of causes of action?
No, it does not. It is not limited to particular types of causes of action. That is a common misconception, I think. The classic cases do often involve defamation or other types of causes of action that really involve speech or that require some sort of speech-related activity in order for there to be a cause of action. Defamation is a perfect example. False light invasion of privacy is another kind of example. But it can be applied to all different types of causes of action, and the list is long. I mean, you've seen it. I've seen it in context of negligence, breach of contract, intentional interference with prospective economic advantage, you name it. I mean, it can really be applied.
I've seen right of publicity cases. It's quite common in my world, and we've even seen recently some employment cases.
Yes.
Employment discrimination causes of action have been found by the courts to be subject to an anti-SLAPP motion in particular circumstances.
Yes, that's correct. So it really does run the gamut, and it's not just a particular type of cause of action. If you're a defendant and you're thinking, I wonder if this is going to apply, I think a good rule of thumb is the first thing you ask yourself is my client getting sued for something they said? Okay? If they're getting sued for something they said, there's a decent chance that the anti-SLAPP statute could apply. I mean, there's obviously other factors to consider in this first step in the analysis, but that is the first clue. Another is my client getting sued for something that was in furtherance of either speech or petitioning activity? So I'll give you an example of that. Quite a while ago, one of my clients, a television station, got sued because they had a camera that they took into an office and they recorded an interaction between the reporter and a doctor. Okay? And the doctor sued really just for one thing, for illegal recording, an allegedly illegal recording. We brought an anti-SLAPP motion saying that, now bear in mind the illegal recording is one thing and then the news broadcast is another, right? We brought an anti-SLAPP motion saying that the recording was conduct in furtherance of speech activity. The whole purpose of recording the conversation was to put on a news story. And the Court of Appeal agreed with us, and that was the first case to apply the news gathering conduct to an anti-SLAPP motion, and the court held that that was appropriate. Even though the client was not getting sued for their actual speech, they were getting sued for their conduct that we argued successfully was in furtherance of speech.
Okay. So far we've just been talking about sort of the first prong of the anti-SLAPP statute, which is whether you're kind of within the scope of the statute. But just because you're in the scope doesn't mean that you win your motion.
No, it certainly doesn't. And I definitely want to go to the second step. But let's talk for just a second about what constitutes a public interest. There's a huge variety of cases on this. I mean, there are hundreds and hundreds of cases in California alone talking about the anti-SLAPP statute. And that is really a testament to how much law is developed, but also how much the law is still developing in this context. So if you look at the public interest component, there's a wide range ranging from one California Court of Appeal case that actually says that a matter of public interest is basically anything that the public is interested in.
I don't even think it qualified it with the word basically. It said literally that an issue of public interest is anything that the public is interested in. That's the Nygaard case.
That's correct. That's the Nygaard case. And then at the other end of the spectrum, there is a line of cases, most prominently the Rivero case, that talks about how there's really only particular categories of things that would amount to a public interest. For example, things that affect a large group of people or that involve someone that's in the public eye. Those are just two of the examples. So you do have this range of what is going to be defined a matter of public interest. And we'll talk in a little bit about a California Supreme Court case that may start to resolve what a matter of public interest really means. But it's important when thinking about anything with anti-SLAPP in California that the statute itself and the California Supreme Court have made very clear that the statute is meant to be construed broadly. In other words, you need to give a lot of deference to protecting these speech.
Right, and interestingly, so that language about interpreting broadly was not in the original statute when it was passed in 1992. What happened was the courts were interpreting it narrowly, and the legislature said, no, we really meant it when we enacted this broad protection for free speech. So several years later, they enacted this amendment which said to courts, you must interpret it broadly.
That's right, and people file tons of anti-SLAPP motions. So that's step one. So step one, the burden's on the defendant to show that the anti-SLAPP statute applies. Then we move, if that's satisfied, then we move to step two, and the burden switches. Now the burden is going to be on the plaintiff to show with admissible evidence that they have a probability of success on the targeted causes of action. So what does that mean? That means that they have to actually have evidence, and this is not like a demur or a motion to dismiss or something like that where the allegations in the complaint are treated as true. That's not the case. They actually have to have evidence to show that they have a chance of winning their cause of action. Now, some courts have likened this to the summary judgment standard because the court is not supposed to weigh the evidence in an anti-SLAPP motion. They're not supposed to say, okay, well, this person's evidence versus this person's evidence. But the court can definitely say that certain evidence is inadmissible. And so very often, those in the defense perspective, like myself, they'll file objections to the evidence that is presented by the plaintiff, right? To say, well, okay, you presented evidence, but it's not admissible evidence. It has to be admissible evidence. But the court is not supposed to weigh admissible evidence against itself. And so it will revert to the concept that's at summary judgment. As long as there's not a disputed issue of fact, then the court can make a decision. So that's the burden that's on the plaintiff in the second step of the analysis.
So now we're going to get to, so you've described the basic process, but why do defendants love the anti-SLAPP statute so much?
Right.
That's what we're going to get to right now.
Yes, and especially in California. The statute's really strong for a variety of reasons, and here's what happens when an anti-SLAPP motion gets filed. First, all discovery is stayed upon the filing of the anti-SLAPP motion. This means, let's say you're just about to run out of time to respond to interrogatories, request for admission. It stops, clock stops. You're supposed to have your client deposed tomorrow morning, clock stops. Discovery stops. Now, it is possible for a plaintiff to go in and get leave of court to take discovery, but they have to make a motion and the court has to approve it. And it should be very limited, and it should only apply to whatever arguments that need to have discovery. In other words, if you've got 7 different arguments that support your anti-SLAPP motion, defendants have argued and successfully argued, look, 6 of these are as a matter of law. No evidence would ever help. So why don't court, Your Honor, why don't you decide those issues first, and then only if those all fail, then we can go to the 7th and talk about whether any discovery is necessary before you rule on the 7th.
Are there any circumstances under which courts would routinely grant discovery motions in the anti-SLAPP context?
I think the only circumstance that really springs to mind would be if the defendant is raising either a defense or attacking a particular element that really requires some sort of factual analysis. One of the examples that comes to mind is if the defendant's only response, for example, in response to to a defamation cause of action would be actual malice, then the defendant is saying, I didn't know that this was false, or I didn't act recklessly as to the truth or falsity of the statement, then the plaintiff may come back and say, and again, you may have that argument in addition to other arguments, the ones as a matter of law should be determined first, but if it's all about actual malice, I could picture a court
Right.
saying, well, we need to have some discovery so the plaintiff.
Right, because that information is only going to be in the mind or the documents of the defendant.
That's right.
Right.
That's right. So that's a circumstance where I could see it coming up. But it is very unusual to get discovery in the face of an anti-SLAPP motion. It does not happen often. It's not supposed to. I mean, that's the point of this provision in the statute. So that's one powerful tool that comes out of using the anti-SLAPP statute. Another, and this is really important, is that if the defendant prevails on the anti-SLAPP motion, then the defendant is entitled to a mandatory award of attorney's fees and costs. The only thing that the judge gets to decide is whether or not the amount is reasonable. And there's ways to determine that with the lodestar method, et cetera. But that is a very powerful tool because, say, for example, you're a defendant and you've been sued for 6 causes of action and you only attacked maybe 1 or 2, that can still be, tens of thousands and in some cases even 6 figures worth of attorney's fees just attacking those causes of action. And then in the middle of the case, all of a sudden the plaintiff owes the defendant, $50,000, $100,000, $200,000 because they've lost.
And I found that, the scenario that you described is obviously important where you actually do get an award, but I think equally as important is the deterrent effect that the fee shifting provision of the California anti-SLAPP statute has. So if you are a plaintiff's lawyer and you are thinking about filing the lawsuit and you are relatively sophisticated and know about the existence of this fee shifting provision, you got to think long and hard and have this very, tough conversation with your client saying, if we file this lawsuit that is targeting the defendant's speech, there's a good chance they're going to bring an anti-SLAPP motion. And if they prevail, you, the client, are going to have to pay the defendant's legal fees. I know through pretty considerable anecdotal evidence that deters a lot of lawsuits from being filed in the first place. It's routine if a potential plaintiff will send a letter to a defendant saying we're thinking about bringing this claim against you. It's very common for the defendant, especially if they're a sophisticated media company, to send a letter back saying, if you file that claim, we will bring an anti-SLAPP motion. They cite a bunch of cases, including sometimes even the amount of the attorney's fees award in those cases, and that will stop the lawsuit from ever being filed in the first place.
That's exactly right. Now, and a lot of the evidence of that happening is, of course, going to be anecdotal because it's hard to know things that never get filed in the first place. But it is true, and we do know that there have definitely been, on a per capita basis, fewer defamation lawsuits filed in California and similar types of lawsuits filed in California since the anti-SLAPP motion came into being. And so it is an important factor. And for those who may be watching this who are on the plaintiff side, you've got to think about this. You've got to weigh this. You've got to tell your clients about these risks so that you can make sure that you're giving them the full information and giving them the full picture about what might happen if you lose. Now, if the plaintiff wins the anti-SLAPP motion, it's not a two-way street. The plaintiff does not automatically get fees and costs. The plaintiff has to show, basically just like they would with any other type of motion, that the anti-SLAPP motion was brought in a frivolous manner. That happens from time to time, and courts of appeal have upheld rulings that an anti-SLAPP motion was frivolous. So you don't just file it anytime it seems like it may be a good idea. It should still be a serious motion and have a serious basis before it's brought. So those are two of the important things procedurally. Another really important one is that there's not to be any amendment in the face of the motion in order to try to avoid the effect of the motion. So what happens sometimes is that someone will sue for, let's say, defamation, and then the defendant will come back with an anti-SLAPP motion with the 7 reasons why the defamation claim should lose. And then the plaintiff, realizing that some of those may be pleading defects or maybe other types of problems, will try to amend their complaint. Well, courts have said very clearly and very consistently, no, you cannot get around the anti-SLAPP motion by filing an amended complaint, even if you're in the phase where you can file that amended complaint as a matter of right and don't need to ask for leave of court. Finally, and this is another really unusual and powerful thing for the defense, but also can work to the benefit of the plaintiff, is that the losing party has the right to immediately appeal from the ruling on the anti-SLAPP motion. So what that means effectively for a defendant is if they've got confidence that they've got a good anti-SLAPP motion, they bring it. If they win, they're getting a fee award. If they lose, they have an immediate right of appeal, which is unusual. That just doesn't happen. Usually you have to wait till the end of your case, of course, before you can appeal. But here you get to immediately appeal, which very often will put the entire case on ice for however long it takes to get through the Court of Appeals system. Sometimes that's a year or two.
So one really interesting thing is to see the interaction between the right of immediate appeal and the fee shifting provision. So if the defendant files an anti-SLAPP motion and that is granted, what you will, and then he gets an immediate fee award, what you'll often see is that the defendant is really sort of sitting in the catbird seat at that moment. And you can basically bargain away all or even part of the attorney's fees award for an agreement to drop the appeal.
That's right.
So it's a very powerful tool for the defendant.
It is, and that does happen. And sometimes that will happen where the anti-SLAPP motion wasn't even targeting the entire case, where the defense now all of a sudden has a sizable fee award that's running against the plaintiff, and the plaintiff realizes, well, I have these other causes of action, but even if I win those, which I may or may not win, I still owe X dollars to the defense. So
again, the settlement works well. I get an attorney's fees. I'm the defendant. I get an attorney's fees award of $100,000, say, against the plaintiff. We're about to embark on an appeal, but you can make a pretty good offer to the plaintiff. Say, I will waive the attorney's fees in exchange for you dropping the appeal.
Right, and maybe the whole case.
Yeah.
Exactly.
Yeah.
There were so many anti-SLAPP motions getting filed for a while that the legislature got concerned that it was being used and abused, and the courts were getting concerned about this as well. So the legislature enacted a new code section that revises or gives exceptions to the anti-SLAPP statute. By the way, the anti-SLAPP statute is California Code of Civil Procedure 425.16. The exceptions can be found at 425.17. So what do these exceptions say? The exceptions are basically targeting two different things. First, the anti-SLAPP statute cannot be used against particular types of lawsuits that are brought solely in the public interest. And the statute really defines what that means, and there are certain criteria for what that means, but the concept generally is if a plaintiff is going out and they're trying to effect some sort of good with an impact lawsuit or something like that, and they don't personally benefit from the lawsuit, the legislature said, even if that's going to target speech and petitioning rights, we're not going to let the defendant use it.
We don't want the statute to sort of over-deter that type of lawsuit.
Right, exactly. So, and then the other type where you'll find an exception in the statute, 425.17, is causes of action that are based on particular types of commercial speech. And again, the statute's clear about what the criteria are, but the basic concept there is that often what happens is competitors will be suing each other over, for example, advertisements or statements about their own products or criticizing someone else's products. And so the legislature said we get that involves speech, but we don't want to have this very powerful mechanism used in that particular circumstance.
Right, and just to remind everybody, if you have a lawsuit about speech, but the anti-SLAPP statute doesn't apply, you can still bring all of the regular First Amendment and other defenses that are normally applicable, whether you have an anti-SLAPP statute or not.
Definitely. You can still, and you can do that in various procedural mechanisms, in demur and motion for summary judgment, motion to strike, all these different things. It's still available. You don't lose any of those. This is just a special way to try to get rid of a case early and get all these procedural advantages as you go. So we were talking for a second about these exceptions to the anti-SLAPP statute that are built into this relatively new statute. Those exceptions have their own exceptions because they exclude people like journalists, artists, entertainers. So the concept is even if there's a public interest lawsuit against, let's say, a journalist or a newspaper, the journalist or the newspaper can still invoke the anti-SLAPP statute. So this is meant to insulate those types of people whose job it is routinely to speak, to disseminate content, especially on matters of public interest.
Or another example is, for example, advertising for a movie or a book or a television show. They would normally be excluded by the exclusion for commercial speech under 425.17. But there's that exception to the exception,
right,
which says that if there's a lawsuit about, say, advertising for a motion picture, that kind of lawsuit could be subject to the anti-SLAPP statute.
Right. They still get the defendant can still get the benefits of the statute, the underlying statute. Right. So one other important thing about these exceptions is that if the trial court determines that one of the exceptions applies, the right to appeal goes away, and that's really important, obviously, because one of the big benefits is, even if I lose this anti-SLAPP motion, I have the immediate right to appeal. That's generally correct, unless the trial court says, no, but I'm finding that one of the exceptions applies, in which case there is no right to immediate appeal anymore. So as I mentioned earlier, there's just been so many different cases that have come up involving the anti-SLAPP statute over the past 25 years. The California Supreme Court has issued a lot of its own decisions about this, and right now, as of February 2018, there are 4 cases pending review in the California Supreme Court just about the anti-SLAPP statute. That's a lot. Okay, so we're going to talk about all 4, but really focus on the first 2. One is called Rand Resources versus City of Carson, and in this case, the court may determine and somehow try to resolve the dispute in the lower courts about what constitutes a matter of public interest. So I mentioned earlier that there's this kind of wide range from the Nygaard case that says anything the public's interested in counts as a matter of public interest, all the way to, well, there's really just a few categories of what we're going to consider a matter of public interest. So in this particular case, the court may somehow resolve that. Dispute is a strong word, but let's call it that. And in this case, what happened was there was a city that wanted to build an NFL stadium, City of Carson, and so they had hired someone to help in that process, and then decided not to use that company and moved on to a different company. Well, company number 1 is suing the city, saying, you didn't treat me fairly. It's basically a breach of contract type of lawsuit. So, but the underlying context, of course, is something that a lot of people are interested in. A lot of people care about an NFL stadium. It's interesting. It's exciting. There's all these different things. So the question is, you've got what could be called a relatively garden variety breach of contract type of case, but you've got this overlay of something that people really care about, which is the NFL, et cetera. So we'll see what happens on that case. The second case that's really interesting coming up in the California Supreme Court is the Wilson versus CNN case. And this is a case, it's an employment case. Mr. Wilson says that he was discriminated against and retaliated against by CNN. And he brought an anti-SLAPP motion. And the Court of Appeal held that the anti-SLAPP statute shouldn't apply because of the allegations of retaliatory motive as opposed to the conduct, the underlying conduct. Now, there are cases that go the other way and say you shouldn't look at motive, you should just look at whatever the acts are.
Right. And just to understand what CNN, the defendant's argument is, yep. So how this is, why are we even talking about an anti-SLAPP statute? CNN is obviously in the business of disseminating news, which is obviously protected First Amendment activity. And they say that their decision about whether to hire or fire or retain somebody is in furtherance of their First Amendment rights. Mr. Wilson was an off-air producer, who would write various things and help put together, packages for CNN. Again, CNN says we have a First Amendment right to decide who we want to have that function performed by.
That's right. And there are cases that support the idea that go the other way, that say, yeah, the news company or the entertainment company, they get to make the decisions about what kind of content they want to put out, which in turn means they get to make decisions about who their employees, their on-air talent, their off-air talent are going to be, because they get to make the decisions about what their message is going to be as well.
Right.
And so, we'll see what happens with this case as well. The two other cases are a little bit deeper in the weeds and have more kind of technical things going on. One is the Newport Harbor Ventures case that has to do with that 60-day clock I mentioned at the very beginning, and whether you can bring an anti-SLAPP motion as to new causes of action, or just particularly for an amended complaint, or ones that came before. And then the Filmon versus Double Verify it gets more into the commercial nature of the speech and the identity of the speaker. And that's another decision that we should be expecting from the California Supreme Court relatively soon.
Yeah, and my takeaway from this is, just 25 years after the enactment of the statute for the first time, we are still fighting over some of the most fundamental, aspects of the statute, including, I would say, probably to me the most important one is the Rand Resources case about what public interest means.
Right.
And again, because of those procedural advantages that JP laid out a few minutes ago, every defendant wants to be within the scope of the statute. Every defendant says, this is a case about the public interest. And of course, every plaintiff says, no, this isn't about the public interest. This is just a standard business dispute about which firm the city of Carson is going to hire to negotiate on their behalf with the NFL.
Right.
Or Wilson versus CNN. This isn't a case about free speech. This is about whether this employer has engaged in employment discrimination with respect to this particular employee. Again, every defendant wants to be within the scope of the anti-SLAPP statute. Every plaintiff says, no, this is just a narrow case about this particular plaintiff and this particular defendant. All right, so JP has led us through how the California statute works. Now I'm going to sort of expand the discussion to the rest of the country. I should mention that in my job here at the Motion Picture Association over the last several years, a significant portion of my time has been spent working on getting either new or improved anti-SLAPP statutes enacted in a number of states. So let me talk a little bit about the landscape and then talk about some of the legislative battles that have been going on across the country. So here you see a map of the approximately 30 states and the District of Columbia that have enacted anti-SLAPP statutes in some form, again, starting with Washington State back in 1989. The states with anti-SLAPP statutes are in green. The states that have no anti-SLAPP statute are in gray. And you'll see Washington and Minnesota with kind of crossed lines through them, and I'll explain why that is in a few minutes. So 30 states with anti-SLAPP statutes on the books. However, that sort of obscures what's really going on the ground, because those 30 statutes vary pretty widely in how strong they are, what kind of case, what kind of causes of action they cover, and whether they have some of those features like a discovery stay, like a right of immediate appeal that JP laid out in California. So this is a little bit of a subjective test here, but by my reckoning, of those 30 states with statutes on the books, only about 15 are strong, including California. Some of the other states, maybe they're not quite as strong. I would still put them in the same category. But then a number of others that have anti-SLAPP statutes on the books, they're actually very narrow. Let me just give you an example of what I mean. A state like New York. In New York, the statute only applies where the plaintiff is what the statute refers to as a permittee. So
that's like the classic
anti-SLAPP scenario where a developer is seeking a permit to build a project. Other states, they might only apply where the defendant is actually speaking before a governmental body, like a state legislature or a city council or a planning board. Those would help people in those kinds of scenarios, in those kinds of contexts, but it would not typically help, say, a news organization that gets sued for its exercise of a First Amendment right on a public issue, or a movie studio or television network that gets routinely sued here in California and that is able to invoke the anti-SLAPP statute.
Why do you think some states have stronger statutes than others? What leads to that?
There's a variety of reasons. Some is happenstance. You might have a particular activist or a law professor or a legislator who is interested in this particular issue. There might be some examples of SLAPP lawsuits. That's redundant, but there are examples where a developer has sued an individual and sort of shut them up unfairly.
Oh, in that state, so that the legislators can understand, oh, this is actually affecting your constituents.
Exactly. So in the states where I've worked on these issues, where we've tried to enact and help enact a new or improved anti-SLAPP statute, the legislators, some of whom are not even lawyers, don't understand sort of the ins and outs of the litigation process. Might not understand, well, why is it so important that you have the right of immediate appeal, or why does the discovery stay so important? But what they will understand is specific examples that you can give them of, there was a citizen who spoke out in front of her city council in this particular town, and she got sued.
She got sued for that.
And she didn't have a lot of money. She couldn't hire lawyers to fight a lawsuit for several years, so she had to go away.
Right.
This is the kind, and you explain to them how this statute would help address that particular scenario.
Right.
Again, so 50 states, but only about 15 actually have what I would refer to as strong statutes. So let me talk a little bit about the trends that we see going on across the country. Some of the trends are very good. I think there was a trend that it's noticeable over the last several years of states either that did not have anti-SLAPP statutes at all, enacting them for the first time, and again, pretty good ones, or states that actually had them on the books but were fairly narrow that expanded them. So you see over the last, 7 or so years, brand new statutes in states like Texas and Oklahoma, a significantly improved statute enacted in Florida in 2015 that we were involved in. We were also involved in an effort to significantly expand a statute in Georgia. And then there were brand new ones passed within the last couple of years in Kansas and Connecticut. One thing that's interesting, you see the list of states, both blue and red states.
Right, and swing states. It's everything. Yeah,
and swing states. So, this one thing that I really enjoy about working on these issues in the state legislatures is this is not a partisan issue. You have people on the left and the right, Democrats and Republicans.
Everybody likes free speech.
Everybody likes free speech, but it's interesting. Obviously you make different arguments to different types of people depending on what appeals to them. But you see on the left some of the traditional free speech groups. You have the groups like the Reporters Committee for Freedom of the Press. You have entertainment companies who are generally identified with the left, supporting them on free speech grounds. But it's interesting, in states like Texas and Oklahoma, yes, of course they care about free speech, but some of the conservative groups that have been pushing the anti-SLAPP statutes really sort of frame it as tort reform.
Right.
Which is an issue popular with Republicans and those on the right who sort of fought against what they refer to as frivolous lawsuits of all types. And this is just one form of frivolous or at least meritless lawsuit. So again, it's an interesting issue where you have groups like the American Legislative Exchange Council, which represents conservative state legislators legislators coming together with groups on the left, like in some circumstances the ACLU or the Reporters Committee for Freedom of the Press, locking arms with press organizations that they might not normally align themselves with.
Right, interesting, yeah.
So again, just to talk about some of where the advocacy groups sort of line up. You have news media, you have groups like mine, the Motion Picture Association, other entertainment and broadcasting companies, First Amendment advocates like the ACLU, the Reporters Committee for Freedom of the Press, the Media Law Resource Center, internet companies, that they themselves engage in free speech, and they have users that engage in free speech. Yelp, very interestingly, has been a big proponent of anti-SLAPP statutes, both at the state and we'll get to later in the federal level, because people who post reviews of businesses are frequently sued by those businesses when they give them a bad review. So Yelp fights both when they get sued and they also want to protect the rights of their users to engage in this kind of protected speech.
Right.
And then again, you have conservative and libertarian groups who both support free speech sort of standing on its own, but support anti-SLAPP statutes as a means of tort reform.
Right.
It's interesting. You haven't really seen a lot of organized opposition, at least publicly, to the legislative efforts over the last several years. To the extent that there is opposition, it traditionally comes from two sources. Plaintiffs' lawyers who have a kind of ideological, quasi-religious opposition to the fee shifting provision in the anti-SLAPP statutes in particular. And then you have real estate interests who were, again, the original target of anti-SLAPP statutes, because there were a number of cases where, again, developers would sue individuals who had banded together to oppose a particular project.
What's the developer's argument here against the anti-SLAPP statute?
The developers and others who oppose anti-SLAPP statutes say, what, these statutes unfairly put a thumb on the scale in favor of defendants. And they say, yes, of course we support free speech, but despite the First Amendment, we have defamation laws on the books, and they have been on the books for hundreds of years. And
there's other procedural mechanisms.
And yes, you can raise your First Amendment arguments, you can raise all the traditional arguments that anyone can bring against any types of lawsuit, in particular defamation lawsuit. But again, their argument is that the anti-SLAPP statutes puts too many hurdles in their way to getting to a jury, taking away their typical right to discovery. Essentially, in their words, forcing us to file our when we file our complaint, already have amassed our evidence, which is not the normal rule. The normal rule is you can file a relatively bare bones complaint, and as long as it's the allegations in there, if true, if they could get you recovery, you can get past the motion to dismiss, and you can we're off to the races with discovery. And again, that it makes it much harder for them to do that, which is and so that's their argument.
Got it.
Again, the counter argument is what. First Amendment rights are special, and
they're being threatened, and they have been threatened,
and they're being threatened, and they have been threatened, and there's real examples of plaintiffs misusing the courts to squelch speech that is protected, but again, at least certain defendants don't even have the financial ability to fight all those First Amendment arguments, even if they would ultimately prevail.
Right.
So again, the good trends is you saw that half dozen or so states that have enacted statutes, either new or improved over the last 7 or so years. There's also either legislation that has currently been introduced that is being debated now, or I'm aware of groups that have organized to introduce new legislation in that's about 10 states that I have listed there, including places, important, large states like Ohio, New Jersey, and New York. I've actually made numerous trips to Albany, New York over the last 5 or so years. The last 3 sessions, the state assembly has passed a significantly improved anti-SLAPP statute over the one that that New York currently has on the books. Unfortunately, we haven't been able to sort of get it over the goal line in the Senate, but we are still trying. New York is really the...
How about the governor? Has he expressed interest?
The governor has not been involved yet, so we don't know his position yet. But to us, it's a shame. I mean, New York is arguably the media capital of the world. You have television networks and major newspapers and magazines that are headquartered in New York, often are sued for exercise of their First Amendment rights, and really don't have a good way of having the courts address those important First Amendment issues early on in the lawsuit before everyone has had to spend a lot of time and face the burden of discovery.
Right.
So, again, we're relatively optimistic that at least some of those states that I have listed there will enact either new or improved statutes over the next several years. And then one recent development that I think bears watching is the Uniform Law Commission, which is a very respected body that promulgates these uniform laws that state legislatures can then go and enact. So everyone's heard of things like the Uniform Commercial Code, the Uniform Probate Code.
Right.
Well, relatively recently, they decided to go ahead and try to draft a uniform anti-SLAPP statute that could be enacted by any of the state legislatures, whether they have a current statute on the books or not.
And you're working on this, right?
Yeah, so what they do in these, when they embark on one of these projects, is they form a committee, and it includes people who are sort of expert at legislative drafting, and then they also include a number of subject matter experts. So I'm going to be participating as an observer. Hopefully I'll have the ability to have some input into this process, and we actually have our first meeting of the drafting committee in March 2018, and I'm told that those projects usually take a year or two before they release a final product, which then, of course, legislatures can then enact, either in full or adopt as much of that as they would like.
And the hope is that the uniform statute will be a strong one, like California is.
That's the hope. I mean, personally, if it were up to me, I would take the California statute and simply export it to the other 49 states in the District of Columbia. Obviously, other states have their own interests. They have their own codes of civil procedure that might not work exactly the same as California's, and it's going to have to be tailored to individual states. But yeah, it's absolutely true that California, I think, is considered the gold standard of anti-SLAPP statutes that are currently on the books.
Right.
So we've talked about some of the good trends. There's also a few trends that are concerning to those of us who are big supporters of anti-SLAPP statutes. I mentioned that Washington State and Minnesota, you saw my map a few minutes ago, had those slashed lines through them.
What happened?
So what happened is both those states had good anti-SLAPP statutes on the books. Both of those statutes were struck down by state courts. Again, Washington, their very first state to enact an anti-SLAPP statute, and then Minnesota. And what the courts said in both of those states, very similar rulings, is they said that the states' anti-SLAPP statutes conflicted with their respective state constitutions' guarantee of a jury trial. And what they said is that the way that we interpret the statutes that have enacted by our legislatures is that they give the trial judge the ability to essentially make factual determinations that the state constitution reserves for a jury. And
why don't they have something like California, right, where California says that you can't weigh it? That wasn't what was happening in Washington and Minnesota? Was it different?
So it's interesting. There? You actually had fairly similar wording in the California statute as in at least the Washington statute, which I'm most familiar with. And in California, relatively early on after the statute was enacted, you did have people making exactly this argument.
Right.
And essentially what the California Supreme Court said is, yes, it would be problematic to have the trial judge weigh evidence, but so we're going to interpret the statute as saying, no, the trial judge is not allowed to make factual findings, not allowed to weigh evidence. So, but essentially what the trial judge is supposed to do is evaluate the evidence in the same way that it would be doing, that the court would be doing evaluating a summary judgment motion. Not to weigh evidence, but say, is there a dispute in the evidence that I need to resolve in order to figure out who wins as a matter of law.
Right.
And that's how the California statute has survived a similar constitutional challenge.
Washington and Minnesota are not meeting the same fate.
They didn't. And again, unfortunately, what the court said is the way that I read the statute, it simply conflicts with those state constitutional guarantees of a jury trial. And I expect courts in other states, it's my understanding that all 50 state constitutions do have a guarantee of a jury trial.
Right.
So I expect similar arguments to be made in other states, and we'll see how those play out.
Do you have any idea if there's any prospect of amendments to the Washington or Minnesota statutes?
Yeah, I am aware in Washington there hasn't been a new bill introduced yet, but it's my understanding that those First Amendment advocates have been studying the decision, studying the way that the current statute is drafted, and trying to figure out if there's a way to rewrite it so that it would withstand a challenge under the state constitution.
Got it.
And
Good.
we're hopeful that'll be done within the next couple. So I've talked about some of the positive trends. I've also talked about this negative trend. And then there's an important issue on which the trend lines are kind of mixed. And that's the issue about whether state anti-SLAPP statutes apply when you are litigating a state claim in federal court, which typically would happen when you have diversity diversity jurisdiction, or when you have a mix of federal claims and state claims, and the state claims are heard by the federal court under supplemental jurisdiction under, was it 28 USC 1367C. So just getting back to some of the basics, generally speaking, state anti-SLAPP statutes only apply to state causes of action, like defamation, breach of contract, state employment discrimination, etc. So the question arises, well, if you're litigating one of those state causes of action that might be subject to an anti-SLAPP motion if you were in state court, can you still bring an anti-SLAPP motion when you're litigating in federal court?
Right.
And the courts are split on that issue. So the First Circuit has said yes, a state anti-SLAPP statute can apply in federal court. The Ninth Circuit has said yes, mostly. It said that the sort of the basic provisions of the California anti-SLAPP statute do apply.
You can bring the motion, but you might not get everything.
You don't get all of the benefits. For example, the court has said, yes, you can bring one of these motions, but you don't get the benefit of the discovery stay when you're in federal court, because that conflicts directly with the federal rules of civil procedure. There's also several jurisdictions that have said no, that when you're in federal court, there's no such thing as an anti-SLAPP motion. We're governed in federal court by the federal rules of civil procedure, and it says you can bring a motion to dismiss under Rule 12. It says you can bring a motion for summary judgment under Rule 56, but it says absolutely nothing about an anti-SLAPP motion, so you can't bring them. They cite to the case that we all learned about in our first year of law school in civil procedure class, Erie Railroad versus Tompkins, which says essentially that when you're in federal court litigating a state law issue, the substantive state law applies, but the procedures of the federal courts, in other words, the federal rules of civil procedure, apply. They say, this anti-SLAPP thing, that sounds procedural to me, so it just has no place in federal court.
So with the First and the Ninth Circuits find that their anti-SLAPP statutes that come up from the states within their jurisdictions are, at least in part, substantive.
Right. And their argument is the underlying purpose of these statutes is to protect the right to free speech, which is an issue of substance. Right. And therefore it's substantive for purposes of Erie. Again, there's some courts, including the DC Circuit, a federal district court in the Northern District of Georgia, recently a bankruptcy court in New York, have all said, no. What these anti-SLAPP statutes do is establish a procedure for filing a motion and what you can do with discovery and when you can appeal. That sounds procedural to me, they say.
And often they are found in the Code of Civil Procedure or the rules of civil procedure for those respective states, which I think complicates the issue a little bit. Exactly.
So what we really have is an emerging circuit split on this issue. I mentioned the case in the Northern District of Georgia. As we speak, that case is on appeal to the 11th Circuit. It's probably going to be heard for oral argument later this spring. We'll make a decision later this year. Again, there's this emerging circuit split. A lot of people, there's already been a couple cert petitions on this particular issue. I think there's a lot of people who think that it's inevitable that one day the U.S. Supreme Court will issue a decision about this important question, again, whether these state anti-SLAPP statutes apply when you're litigating in federal court.
It seems like there might be some concerns in the Ninth Circuit, too, that there's a trend developing. Right?
That's right. As I mentioned, the Ninth Circuit has several opinions which do say that the state anti-SLAPP statutes apply in federal court. However, there are a number of judges within the Ninth Circuit who have written concurrences or dissents saying, no, this is an issue of procedure. The anti-SLAPP statutes are procedural. They have no place in federal court. That effort was led by now former Judge Alex Kaczynski, who recently left the Ninth Circuit. He had written a number of these concurrences, but there's at least 4 judges still on the Ninth Circuit who are on record as saying that, again, anti-SLAPP statutes, state anti-SLAPP statutes should not apply in federal court. That includes, interestingly, Judge Gould, who previously had taken the position that they should, but has acknowledged in a recent concurrence that he now believes that he was wrong previously, and he changed his mind and now believes that these statutes should not apply in federal court. Okay, so we've been talking about this issue about whether the state anti-SLAPP statutes can apply in federal court. And there's some actually really interesting, difficult, complex areas of constitutional law, of federal courts and civil procedure.
Right.
Again, these doctrines haven't provided a clear answer to the courts that are split. Federal judges have come out different ways. But there's also a lot of talk about sort of what's going on a little bit below the surface and what's sort of going on in the minds of federal judges, why they might be more or less eager to have these anti-SLAPP motions litigated in their courts. So what's your theory about sort of why some federal judges, at least, may seem reluctant to have these anti-SLAPP motions litigated in their courtrooms?
Right. No, that's a great question. I mean, look, from someone who files a lot of anti-SLAPP motions, my perspective is that it should apply in state court, should apply in federal court. All the protections are substantive. They should all apply in federal court. That's not how it works out. So why is there anything beyond this kind of procedural or constitutionally based perception about how and whether the anti-SLAPP statute should be applied in federal court? I think there is. I think generally there is a consensus, not scientific, much just about anecdotal, that judges in state court and in federal court are getting weary of anti-SLAPP motions. There's a lot of them that get brought. A lot of them win, and they're valid, and they should have been brought. Some don't, and some shouldn't be there and shouldn't have been brought in the first place. But I think in federal court that gets compounded when you've got federal judges saying, why am I having to follow this state law, this state procedural law in my court when I'm a federal judge? And if you look at like the Ninth Circuit, for example, you've got Oregon, you've got California, you've got Nevada, and if just as examples, and they have to look at all these different state laws as opposed to just applying the federal law, the federal rules. I mean, to me, the answer to that is, well, you have to do that anyway, because if you've got a diversity case or you've got supplemental jurisdiction, you got to look at state law all the time. What's different?
Yeah, I mean, in fairness, I can see it being sort of a bit jarring to a federal judge. They hear all sorts of cases on all sorts of issues, but they think, every civil case I have,
I know the rules.
I know the federal rules of civil procedure, and they apply whether I'm doing a copyright case or a patent case or a fraud case or whatever. And then all of a sudden they say, wait a second, I have to deal with the state law, and that has all sorts of different rules. It says I have to, I might have a discovery stay, or what's this thing called a special motion to strike? I don't see that anywhere in the federal rules.
And this two-step process and all these different things, right? Yeah. And then they are feeling like they have to go back and look at state law, state court decisions to understand how to apply these issues. But again, the way I look at it, that happens all the time. I mean, it is a substantive law, and they should feel comfortable, and a lot of judges do, and they're fine. But there is, as you mentioned, kind of, at least in the Ninth Circuit, a growing minority of judges who have articulated their discomfort with the anti-SLAPP statute and its application in federal court.
Right. All right. So we've been talking for the last several minutes about sort of this patchwork of laws around the country. Again, approximately 30 states have these on the books, but that means 20 don't at all. And then we have this emerging split among the federal courts about whether the state anti-SLAPP motions can be brought in federal court at all. So given this kind of patchwork,
what can be done?
What can be done? I mean, and again, this patchwork creates the opportunities for forum shopping,
right?
Which is considered not a good thing. So proponents of anti-SLAPP statutes at the state level have realized that, well, maybe the solution is to pass a federal anti-SLAPP statute. Mm-hmm. And in fact, one was introduced back in 2015. It was known as the Speak Free Act of 2015. There were a bipartisan group of sponsors. You had Blake Farenthold, who's a conservative Republican from Texas, joining up with Anna Eshoo, who's a liberal Democrat from Northern California. The chief proponents of this were a group called the Public Participation Project, with a First Amendment advocacy group, and as I mentioned, Yelp, which has been very active on these issues.
Right.
The statute is based a lot on the Texas statute, which is very similar to one that has been formulated by ALEC, the American Legislative Exchange Council. And in some ways, it's very similar to the state anti-SLAPP statutes. It has the same two-step process and has a lot of the same features, including a discovery stay and a right of immediate appeal and a mandatory award of attorney's fees for a prevailing defendant. But there's also some really complicated wrinkles that I think people are still sort of grappling with how it would work in practice. So it's clear that it would apply that, if you had a federal cause of action in federal court, it would apply. Right. And again, as of today, those kinds of causes of action are not subject to an anti-SLAPP statute at all. Right. Again, these state statutes only apply in federal court. So that would be a big change, is that these federal statutes for the first time would be subject to an anti-SLAPP motion. But in order to cure this perceived problem that certain states don't have anti-SLAPP statutes at all, it would create a really interesting procedure, which is pretty novel, which would essentially allow removal of any claim that falls within the scope of the federal statute from a state court to a federal court where the defendant could file an anti-SLAPP motion.
So even if it was a small claim, something that was not, or it was just a small part of the case, you can pull. Wow.
Exactly. So every litigator is familiar with diversity jurisdiction, where if you have someone from one state suing somebody from another state, that can be removed to federal court, and you'd litigate the state law issues there. But importantly, there's still a monetary threshold of $75,000. So if you have a really small claim in state court, that's not removable, even if it is between people of different states. Right. So again, this proposed federal anti-SLAPP law does allow for removal, but there's no monetary threshold at all. So to illustrate it, let's say that we were in South Dakota, which has no state anti-SLAPP statute on the book. But if this proposed federal law were enacted, and let's say I sued JP for defamation on a public issue, but I said, you know what, I'm only going to seek $1,000 and no more. JP could remove that lawsuit from state court in South Dakota to federal court in South Dakota, and he could invoke this federal
based on my defense.
Based on your defense.
Well, that kind of makes sense because it's a federal question in a way, because it's a First Amendment defense. That would be
the argument. Yeah. The counter argument is the federal courts are already overburdened. We actually don't have that many federal judges, and depending on the district you're in, some of them have enormous caseloads. Do they really want to be having to handle what's essentially a small-time state court cause of action, at least as the way that the Speak Free Act was formulated? That kind of lawsuit could end up in federal court.
Right.
You also have the interesting issue to people at the movie studios and other entertainment companies, like those that we represent at the MPAA, who had some concerns because for the very first time, again, federal claims would be subject to an anti-SLAPP statute. One of the types of federal claims that we at the MPAA care very much about are copyright claims.
Right.
So we had
which basically always involves some kind of speech.
Always involve almost any copyright claim involves some form of speech. So we, of course, would bring anti-piracy actions against defendants, who, for example, have a website that streams pirated copies of movies. Right. We had some concerns that if not crafted properly, the defendants in these cases would be able to file an anti-SLAPP motion and give them all sorts of advantages that, frankly, they don't deserve because they're engaged in blatant piracy. So again, this bill was introduced back in 2015, which was the previous Congress. There was a hearing in the House Judiciary Committee, or one of the subcommittees, and a lot of these concerns were aired. As is commonly the case, the first time a bill like this a complicated bill like this is introduced, it doesn't necessarily make it over the finish line. In the current Congress that we are in, I know there's been people talking about maybe making some changes to this bill. and possibly reintroducing it in a different form, but that has not happened, at least as we're sitting here in February of 2018. There was a hearing in one of the subcommittees of the House Judiciary Committee where proponents explained why this would be a good thing, and then others raised some of the concerns about at least the way that this particular bill was formulated. It didn't. There was never a vote on the House floor or in the Judiciary Committee itself. That's not uncommon. And, a complicated bill like this will often take several attempts before it gets very far. So here we are in the new Congress. I know that proponents of this issue are talking about ways to maybe make some changes and reintroduce a new bill. That has not happened as of yet. And it's interesting to see sort of who, when alerted to the bill, may come out of the woodwork. I mean, one question is federal judges who sometimes actually lobby on legislation themselves. If they're going to raise concerns that this might, for example, increase their docket, their workload significantly. And then I think another of the big questions is whether President Trump would sign or veto a bill if Congress actually enacts one. Famously during the 2016 campaign, President Trump said he wanted to open up the libel laws. No one's exactly sure what that meant. The president doesn't really have the power to change state libel law or to change what the Supreme Court has said, in New York Times versus Sullivan and a bunch of other cases that have sort of put some hurdles in the place of in the way of libel plaintiffs. But I think it's fair to say that what he was really getting at is he likes to be able to sue the press when they say bad things about them, and he's not in favor of making it more difficult for libel plaintiffs to pursue their cases. So I think
he might not be in favor.
I think there's a lot of skepticism among First Amendment and media advocates about whether President Trump would sign a federal anti-SLAPP bill if Congress sends one over his desk. Although I will say, President Trump has been a frequent libel plaintiff, but he's also occasionally a libel defendant, and there are actually 2 pending cases where he is a defendant and has invoked state anti-SLAPP statutes.
In federal court.
In federal court.
Yeah.
Maybe he's learned some lessons and will actually come around to supporting an anti-SLAPP statute one day.
Right.
So anyway, hopefully this has given everyone a good primer on the way that the statute works in California and some of the trends that we're seeing, both good and bad, across the country from the perspective of those like JP and myself who are strong supporters of anti-SLAPP statutes. And thank you for listening.
Thank you.